Recording in progress.
All right, we'll call them. Oh, it's a lot of echo. Can we fix that? Testing. Testing. That's what we got. All right. I'm going to call to order the Planning Commission meeting for the City of Oregon City, February 12th, 2024. Can you do the roll call, please?
Commissioner LaSalle is absent, excused absence. Commissioner Dole. Commissioner West. Commissioner Laws. Commissioner Schlagenhofer. Vice Chair Espy. Chair Stoll.
Here. I'll move on to meeting minutes. If you all had a chance to review them, do we have a motion or discussion?
Move to approve the meeting minutes.
I'll second that.
Okay, been moved and seconded. Any discussion? Call the vote, please.
Commissioner Dole.
Aye.
Commissioner West.
Aye.
Commissioner Laws.
Aye.
Commissioner Schlagenhofer.
Aye.
Vice Chair Espy.
Aye.
Chair Stoll.
Aye. All right, we'll move on to the first public hearing, item 2 on the agenda, GLUA 23-00040 and PARK 23-00002. I'll read the script. Public hearings on land use applications are scheduled for tonight. Our role is to conduct the public hearing and to make decisions about the matter before us. In making those decisions, we must apply the applicable codes and laws and cannot vary from or change those laws or codes. A staff report has been prepared for each application and has been made available to the public 7 days before the first public hearing. The staff report identifies the approval criteria that apply to each applicant's proposal. Staff has analyzed the criteria which are contained in the staff report. The hearing procedure that the Planning Commission will follow is set out in state law and the Oregon City Municipal Code. The hearing procedure steps are shown on the Planning Commission website. Public testimony will be called on in the order it was requested. If you wish to testify in person, please fill out a speaker card available at the back of the room. If you wish to testify virtually, you will be called either from a request to speak emailed to city staff at planning@orcity.org in advance of this meeting, or by raising your virtual or physical hand when I ask if there are others in the audience who would like to participate. For the public record, please begin all testimony stating your name and city of residence. If you would like to receive a copy of the notice of decision, please state your mailing address or email address. Testimony and evidence should be directed toward the applicable approval criteria. If you believe other criteria apply in addition to those addressed in the staff report, identify and discuss those criteria and explain how and why you believe they apply to the application under consideration. Any person may submit written material while the public record is open on each application. Any written materials received by the city staff during the time period in which the record is open will be placed in the record. Written materials submitted during the public hearing must be presented to the city staff in order to become part of the record. If a person intends for PowerPoint presentations, reports, pictures, or other exhibits used in their oral testimony to be placed in the record, copies must be submitted to the city staff while the record is open. If they are not given to staff, they will not be included in the record. Any person wishing a continuance to present additional evidence and testimony or to keep the record open to respond to new evidence must make that request before the public testimony portion of the initial hearing is closed. If the Planning Commission makes a decision with which you disagree, any issue that you may wish to appeal must have been raised before the Planning Commission in order to be considered by the City Commission and, in the event of further appeal, to the Land Use Board of Appeals. Without raising the issue on the record with sufficient detail and accompanied by statements or evidence allowing the city and all parties to respond, the issue will not be considered on appeal. In addition to participating orally or in writing and raising all issues during the Planning Commission proceeding, the filing of an appeals must include the required fee. A city-recognized neighborhood association may request waiver of an appeal fee subject to the requirements set forth in Oregon City Municipal Code 17.50.190C5 and 17.50.290C. In addition, the failure of an applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient detail to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Now we will open the record for Oregon City file number GLUA 23-00040, General Land Use Application, PARK 23-00002, Planning Commission Parking Adjustment, Adjustment to Parking Standards at 11731 Longstanding Court. Members of the Planning Commission are to be unbiased. As a result, I will call on each commissioner to disclose any potential conflicts, such as family, financial, or business relationships with any of the applicants or with regard to the land in question. I will also ask whether any of the planning commissioners have discussed the application in question with any of the parties or have independent knowledge of relevant facts, such as from a visit to the site in question. Any member of the audience may question any planning commissioner about their disclosures. At this point, does any commissioner have any conflicts of interest, ex parte contact, bias, or any other statement to declare or have visited the site? If there was a site visit, the planning commissioner must declare what he or she perceived. We'll start on the right with Commissioner Dole.
No conflict, no ex parte, and completely unbiased.
Vice Chair Espy.
No conflicts for the first item on the agenda, possible conflicts on the second.
Okay, we'll get there. Commissioner West.
No conflict of interest, no bias, no ex parte contact. I didn't get out to the site, but I looked at it on Google Maps to see where it was.
Okay, Commissioner Laws.
No bias, no ex parte, no conflicts of interest.
Commissioner Schlagenhofer.
No conflicts of interest, no ex parte contact, no bias, and I did not visit the site, but I have driven by that road hundreds of times.
Okay. I have no conflicts of interest, no bias, no ex parte contact. I did do a site visit today. I drove by this afternoon around 4:30, give or take. And I saw that most of the houses in the neighborhood had two, and I think one had a 3-car garage. Does anyone in the audience wish to question any of the planning commissioners about these disclosures? All right, we'll commence with the staff report.
Thank you, Chair Stoll. My name is Molly Gorin. I am the planner presenting this hearing item tonight, GLUA 23040 and PARK 2302. And this project is requesting an adjustment to the parking standards for a detached triplex development. Okay. It's not. Okay.
You or us?
Okay. Sorry, just figuring out the PowerPoint. Okay, great. So tonight for Planning Commission options, the first option is to approve the files with or without modification to the conditions of approval or findings. The second option is denial of GLUA 23040 and Park 2302 and providing staff with supplemental findings for that. The third option is to continue GLUA 23040 and Park 2302 to a date certain and obtain the required 120-day waiver from the applicant. So the property, the subject property we're discussing tonight is 11731 Longstanding Court. This is in the R8 low-density residential district, which has 8,000 square foot minimum lot size. This site specifically is just over 20,000 square feet, and the neighborhood it's located in is within the Hazel Grove Westling Farm neighborhood, close to South End Road and the South End Road neighborhood. The proposed development is a detached triplex. This proposal includes one unit, which is the existing home on the property, situated in the middle of the property as Lot 2 on the site plan. It also includes 2 new detached units that would each be part of the detached triplex. With this proposal, the applicant is requesting to also include 2-car garages for each of these units with an associated driveway for each unit, and a planning commission parking adjustment is required for this request for 6 garage parking stalls. In the Oregon City Municipal Code, we have standards for minimum and maximum parking for many uses, including triplex and quadplex developments. In this case, a triplex or quadplex development would have a minimum of 2 parking stalls on site and a maximum of 4. The applicant has identified that the maximum parking allowance wouldn't adequately meet the desired proposed development, and has requested approval of a adjustment to allow for 6 total parking spaces on site. So in looking at the definitions of parking space as well as garage, just to clarify that we do count the stalls as the garage spaces, just based off the definition of parking space being unobstructed. We aren't including the driveway in this calculation. So we're requesting 6 total on-site, or the applicant is requesting 6 total on-site parking stalls. For the parking adjustment, just as a little bit more background, we have showing here the location of the garages on the site and the existing condition of the site and how it will be laid out. There will be 2 additional driveway entrances if approved as proposed. So for the applicant's options with this proposed development, they have the option of either submitting an alternative parking plan that includes no more than 4 on-site parking stalls for review, or to obtain a planning commission adjustment to parking standards. Briefly, just going through the parking adjustment approval criteria, we're gonna go through each one, so I'll just be brief. The first one is documentation, that the applicant provides adequate documentation for the request, showing that their parking needs differ from the code. The second one is parking analysis of surrounding uses and on-street parking availability. This one is more geared towards applicants requesting to reduce the minimum parking standard, but we can also look at the parking analysis for this application. Number 3, the function and use of the site. The applicant shall demonstrate that modifying the amount of parking will not significantly impact the use or function of the site. Compatibility, the proposal is compatible with the character, scale, and existing and proposed uses, planned uses of the surrounding neighborhood. Safety, the proposal does not significantly impact the safety of adjacent properties and rights-of-way. And services, the proposal will not create a significant impact to public services, including fire and emergency services. So in evaluating this criterion for documentation, staff found that the applicant provided a site plan, building elevations showing the appearance and layout of the parking garages, as well as providing code responses to the parking adjustment criteria. Parking analysis for surrounding uses and on-street parking availability. This criterion asks you to look at the availability of parking, but it's sort of worded in a way that it assumes you're reducing the minimum parking standard. But staff did look at the nearby site, and on Longstanding Court, staff found that there was approximately 22 on-site parking stalls per the definition in code. And with the new driveway entrances, if and when they're built, would reduce that to 20 on-site nearby parking stalls. For function and use of the site, the maximum parking standards encourage the efficient use of land and transportation infrastructure. Allowing the additional parking wouldn't inherently change the function or site of this as a detached triplex. Excuse me. Additionally, staff didn't receive any public comments identifying that the project would impact the use or function of adjacent sites. For compatibility, the surrounding neighborhood is a platted 1970s suburban neighborhood. And as such, it is common that there are 2-car garages in this neighborhood, but in code, we do not have any specific requirements for single family, even though single family is the predominant use in this neighborhood. By allowing each unit of the detached triplex to have a garage, it would be compatible seemingly with the surrounding neighborhood. For safety, we do review, the driveway and parking standards for compliance with Oregon City Municipal Code at the time of building permit. The engineers will review that. No public comments identifying safety concerns were received, and the applicant is required to demonstrate compliance with Oregon City or Oregon Fire Code with a separate application with the Clackamas County Fire District. And 6, for services, the additional parking would not appear to have a significant impact on public services. We did not require, it's not required to provide transportation impact analysis as part of this development. And the applicant is required, again, to comply with Oregon State Fire Code through a separate application with the Clackamas County Fire District. Based on the findings for the parking adjustment request, staff recommend that the Planning Commission approve GLUA 230040 and Park 23002. The conditions of approval, which I should have included on this and is included in the staff report memo, is just requirements for a building permit obtainal and to obtain the building permits and Oregon Fire Code fire access and supply plan permit.
All right, thank you. Do any commissioners have questions for staff? No? All right, we'll call up the applicant. And please state your name and
JJ Portlock,
city of residence and,
Westland.
okay, go ahead.
Yeah, I think Molly did a great job kind of explaining what I'm trying to do. Really just building a detached triplex under the House Bill 2001 process and trying to keep with the neighborhood, 2-car garages, kind of cohesive with what's already there. So pretty straightforward based on what Molly presented. That's kind of all. I don't have much else to add.
Okay.
Unless there's any questions.
Yeah, does anyone have any questions for the applicant? No? All right, thank you. Do we have any representatives of a recognized neighborhood association, government agency, or other incorporated public interest organization? No? Individuals with public comments? No? You have 5 minutes for rebuttal if you'd like. Okay, sounds good. All right, any discussion or motions? Yep.
I think it's crazy that you can build a 5-story housing unit with a type 2 review, and we need a type 3 review for garages. That's all I have to say.
I don't disagree. All right, any other discussion or motion?
Move to approve GLUA 2340, Park 2300002. I don't know if I got enough to do.
I'll second that.
All right, moved and seconded. Any discussion? No? All right, call the vote, please.
Commissioner Dole?
Aye.
Commissioner West?
Aye.
Commissioner Laws?
Aye.
Commissioner Schlagenhofer?
Aye.
Vice Chair Espy?
Aye.
Chair Stoll?
Aye. All right, thank you.
Thank you.
Before we move on to item 3, it occurs to me that I've skipped the public comment for items not on the agenda. Do we have anyone?
There is no one online.
Okay, sounds good. All right, we'll move on to the next public hearing. Do I need to read the script or just the disclosures?
Just the disclosures.
Okay. Let me get to that part. Okay, we will open the record for Oregon City file number GLUA 23-00026 and MAS 23-00002, Sportcraft Landing Marina Master Plan. Members of the Planning Commission are to be unbiased. As a result, I will call on each commissioner to disclose any potential conflicts such as family, financial, or business relationships with any of the applicants or with regard to the land in question. I will also ask whether any of the planning commissioners have discussed the application in question with any of the parties or have independent knowledge of relevant facts, such as from a visit to the site in question. Any member of the audience may question any planning commissioner about their disclosures. At this point, does any commissioner have any conflicts of interest, ex parte contact, bias, or any other statement to declare, or have visited the site? If there is a site visit, the planning commissioner must declare what he or she perceived. Start with Commissioner Schlagenhofer.
I have no conflicts of interest. For ex parte, I did tell my wife that we are discussing Sportcraft Marina tonight. I've been there many times, launched my boat on the ramp many times. Not recently. I didn't go for this application. I didn't have a site visit for that reason. And no bias.
All right, Commissioner Laws.
I've been going there since I was 6 years old in my dad's fishing boat. I did mention it to my dad. I went to the Two Rivers Neighborhood Association meeting in October of 2022 when the issue was fresh hot, just coming up. And then I just recently went to the Two Rivers neighborhood and nothing was discussed of that nature whatsoever. So that's it. No bias, no conflicts of interest, and no ex parte. So.
All right, Commissioner West.
No bias, conflict of interest, or ex parte contact. And I didn't get down to the site recently, but I will say that many years ago when I was on City Commission that we worked on the park with the steps that abutted the marina there, and we might have even been working on contracts with Sportcraft back then.
All right, Vice Chair Espy.
Okay, so I have two potential conflicts. I worked as a planner back in the late 90s on a conditional use permit for the Sportcraft Marina. And then more recently, I rented a room down in Corvallis at OSU to one of the Dye family members about 4 years ago. So I think those are potential conflicts. I don't really feel like I would be biased, but I'm more than happy to step down and not make a decision on this matter this evening.
Okay. Commissioner Dole.
Sure, thank you. No conflict, no ex parte contact. I did not go visit the site. I did pan around on Google Earth just to get familiar with it, and no bias.
Okay. I have no conflict of interest, no ex parte contact, no bias. I've used the ramp a few times. I did go make a site visit this afternoon. Walked around a bit. It's a marina. All right, anyone in the audience wish to question any of the planning commissioners about these disclosures?
I'm going to participate.
Yeah. All right, we will commence with the staff report.
Thank you. Good evening, commissioners. I'm Pete Walter, planning manager. Before I begin, I'd like to clarify a couple of errors in my staff report. Page 1, hearing date says February 12th, 2024, which is correct, but it was not continued from June 26, 2023. So that needs to be struck out. And on page 10 of 38, there is a table which shows 6 tax lots. That table should be deleted. It is a remnant from Clackamas Park Master Plan staff report. So tonight, the Planning Commission is reviewing a master plan submittal for Sportcraft Marina. Eric Dye is the owner of Sportcraft Marina. He's in the audience tonight, represented by Gary and Nancy Spanovich. The application is a requirement of a lease agreement with the City of Oregon City, which stipulates that the marina apply for a master plan, and that was executed in March 2023. The master plan process is a little bit strange type of review process for this sort of thing, because what I'm going to be talking mostly about tonight are what the existing uses are on the site. There's currently, oh, thanks. Does that work? The city's zoning actually goes to the middle of the river and spans two zones, the mixed-use downtown zone and the the institutional zone, which is a city public zone, and I'll show you a map of that. So the purpose of the master plan was to document the existing uses, those that are permitted in those zones and those that are now considered pre-existing non-conforming uses associated with the marina and the use of the site. There is no new development being proposed, and the conditions of approval that I'm going to talk about later stipulate additional review if there is additional development proposed on the site. And I'll talk a little bit more about that. So, zoning map that I'm showing you here indicates the extent of the I institutional zone, which is the zone just to the north, and then the mixed-use downtown, which takes in most of our downtown, to the south of that. Within the I institutional zone, there are uses on the land. There's a city-owned parking lot, there's a public boat ramp, and there's the access to the docks, but no structures on land. On the water, you have the marina, the dock, and moorages. There's a small retail store. There's an office associated with Sportcraft's use. There is one floating home, which is considered a pre-existing non-conforming use in this zone. And I'll talk a little bit more about that. And there's the kayak and canoe rental place as well. To the south of there, in the mixed-use zone on the water, we have additional moorages, both covered and uncovered. Two floating homes, which, when you look at the mixed-use downtown zone, the zone district allows one or two residential units in conjunction with a non-residential use. So those are permitted in the zone. There's a Sheriff's Marine Patrol dock and office, which was approved in 2013. And then there's Ken's Flotation Services, which is a floating barge that's used for marine fabrication and industrial uses. Since the site was in operation, that they make dock facilities and other types of uses associated with marine and river use. There's also some federal use areas for the Division of Fish and Wildlife, Oceanic, NOAA, I forget what that one means, and Department of State lands down on the south side. This is a aerial view of the northern part of the site. On this map, there's a dashed blue line I've put in to indicate where the separation of the zone districts are. On this map, it indicates where the owner's floating home is, the kayak canoe rental, the office and retail, the slips, the boat ramp, and the lower and upper parking lot. And site and uses on the south include the Sheriff's Marine Patrol, additional slips, two floating homes, more moorages, and the federal agency areas I mentioned earlier, and then the industrial uses that pre-exist with Ken's Flotation Services. So just to reiterate, the only land-based facilities in this plan are not structures, but roads and other public amenities that include a boat ramp, a portable sanitary toilet, a trash disposal area, parking spaces for vehicles and boat trailers, and the gangplank ramp down to the marina. The site has been operating in Oregon City as a landing and moorage and kayak and canoe rental area for large and small boats and recreational small craft for many decades. And we have some additional information about these uses on the site as well. The overlay districts that this site falls within, you have the Willamette River Greenway, which has been in place for a long time. You have the Natural Resources Overlay District, the Floodplain Management Overlay District, and due to the steepness of some of the slopes and banks nearby, Geologic Hazards Overlay District. Those overlay districts, they recognize pre-existing uses. They would come into review if there is additional expansion or development proposed. The process through which that type of thing would be reviewed would take the form of a detailed development plan. And any site plan and design review criteria that apply to structures, and also the parking standards for the parking lot, certain landscaping standards. So you have aspects of the site and structures that don't conform to our design review criteria today because they pre-existed. And then you have two uses that staff considers pre-existing non-conforming. Those are, just to reiterate, in the institutional zone, we have one floating home, and if there was any intensification of that use there, that would not trigger any additional review because we do have some documentation from Senior Planner Christina Robertson Gardner that talks about those 3 floating homes being permitted in the district prior to the rezoning that occurred in 2003. And I'd like to add that into the record. I don't have copies of it, but I have an electronic copy of that email that I'd like to include. The more complicated issue with respect to the Ken's Flotation Services, marine fabrication and industrial use is not a permitted use in the mixed-use downtown zone. However, with sufficient documentation, which both proves when the use was established, as well as shows that whether it was continued in perpetuity for a period of 20 years and has not been discontinued, then through our standard non-conforming use review process, that use could be determined to be a lawful pre-existing non-conforming use. We are not making any decisions about non-conforming uses this evening. We're just making a master plan determination with conditions of approval. So additional review would be required to show compliance with the non-conforming use sections of the code. As I mentioned, the master plan process that was stipulated in the lease agreement is a little bit of a, maybe not the perfect process for which to review this application. The process that really comes to bear is our non-conforming use determination process subject to Chapter 1758 of the code. And because of that, we've made some recommendations for conditions of approval. The first condition of approval recommended is that the master plan have an approval period of 20 years from the date of the notice of decision. The second is that any proposed development comply with the overlay districts, which I just mentioned, Willamette River Greenway, Natural Resources, flood management, and geologic hazard. That continued residential use or expansions or improvements to floating homes within the boundaries of the I zone is permitted, subject to review under the lawful nonconforming uses, structures, and lots section of the code, and that the continued industrial use for Ken's flotation services be subject to nonconforming use determination as well. In my condition of approval in your packet, there's a sentence at the end of that condition that reads, "It is reasonable to believe that the applicant can provide further evidence to support the continuous use of the property in this manner." We'd like to strike that sentence, having not seen that evidence yet. But the process allows an applicant to add evidence into the record that can satisfy a determination of pre-existing non-conforming use. And normally that process is a type 1 or type 2 land use review. And that's what would be required if Ken's Flotation Services is to continue operating within the boundaries of the zone district. Condition number 5, the applicant's responsible for obtaining an Oregon City business license. And condition 6, future development shall be reviewed for compliance with the requirements of section 1758-040, lawful non-conforming structure or site, and the applicable provisions of the code and overlay districts cited above prior to issuance of any permit. And finally, condition 7 is our minimum public improvements and design standards code chapter, which would be triggered if there are additions or expansions of uses on the site. So I am prepared, also within the application, there was a transportation analysis letter prepared that documents the trips on the site well within any normal trip count for this type of use. They're all pre-existing, and it's based mostly off of site observations and slip counts during the summer season as well as the off season. So that TAL has been reviewed by planning staff and would form the basis of subsequent detailed development plan review if there were further additions to the site. Commissioner Espy, before he sat down, did mention that there was a conditional use review in 1990s. There is a lack of information about land use approvals prior to 2000 associated with the site, which made it a challenge to review. I would like to find out more information about that conditional use application and add it to the record. I don't have a copy of that. It sounds like it was an important decision that is pertinent to this application. And having just learned that this evening, I would leave it up to the commission what you want to do about that reference to that conditional use permit. But our recommendations is, your options as Planning Commission are to approve the master plan with conditions as recommended by staff, approve the master plan with conditions modified by the commission, or do not approve the application and direct us to come back with findings to support a denial at your subsequent hearing. Or a continuance, yes. Thank you.
All right, thank you. Questions for staff? We'll start with Commissioner Schlagenhofer. Nothing? All right, Commissioner Laws?
No.
Okay, Commissioner West? Commissioner Dole?
No questions at this time.
Okay, I had a couple. Do those overlay districts kick in for replacement facilities? So something natural disaster, fire, whatever.
Yeah, normally there's exemptions for replacement and repair of existing facilities.
Okay.
It depends on what's been damaged and that sort of thing. But so many of these uses that we're talking about are actually on the water. The parking lot itself doesn't have a lot of structures on it, so, yeah. But as I mentioned, the zoning goes to the middle of the river, so that's where our land use authority lies. There are additional agencies that permit things out on the river as well. You've got Department of State Lands, Marine Board, and the Corps of Engineers, amongst others, yeah.
Okay. You have a question?
I do. I was going to ask maybe a question. Just, Pete, on timelines on some of the conditions. So the non-conforming uses, it's kind of open-ended on when we'd want the applicant to come back for those.
That's a good question. We have discussed whether we would want to stipulate a time frame within which the applicant apply for that. A type 1 or type 2 approval takes, is subject to the state's 120-day rule. But the lease that they are operating under is a separate agreement that is not tied to land use. So if we state that the applicant must, turn in a non-conforming use application within 6 months to a year or something like that, they could do that, but they'd still be subject separately to whatever gets negotiated after this lease agreement or prior to this lease agreement expiring, which is November of this year, yeah.
Okay.
Yeah.
Thank you.
The business lease agreement that you're talking, is that what you're talking about, that the city commission just approved? So that's only a year agreement?
Apparently, yes. Mhm.
Okay. This is a process kind of question, just similar to his. So what happens after tonight if we approve with conditions of approval or don't approve? What's the next step for this?
Well, we would file a notice of decision within which there's a 14-day appeal period. Anybody who speaks tonight, including the applicant, can appeal the decision of the Planning Commission to the City Commission. We don't know whether that would happen or not. And if there is no appeal, then the decision stands for a period of 20 years unless it's amended by the applicant.
Can I add something to that?
Yeah.
So you may be, I think maybe your question may go to, and I'm calling it an order of operations kind of thing. So the master plan that you're reviewing tonight is set up to basically establish a baseline. So we've got a land use baseline of what's out there, uses, structure, site, how it's being used. The next step after that would be for the applicant, whether that's one of the leasee or the subleasees, to come in and go through that non-conforming use determination. Non-conforming determination, because a non-conforming can be for use, structure, site, that kind of thing. After that determination is made, should they wish to intensify their use, expand their use, change something about the use, site, structure, that's when they would go through some type of review process to allow that to happen. And at that point in time, we also review any overlay district that pertain to the site. Did that get at your question a little bit? Okay.
If the applicant wishes to add additional dock space or additional slips, is there a cap on the number based on what it is today with this, or will they be able to increase that within all the other approvals, state lands and Corps of Engineers and so on?
Yeah, I believe under the zoning code, they could ask for additional slips, and, you know, that we would probably ask for an amended transportation analysis based off of that. And the level of review for that sort of thing would typically be a type 2 review. What would make it a higher level of review and coming back to you is if the number of trips exceeded 10% more than what they currently are at. That would be one instance where it would be a type 3 review of the original plan. There's certain thresholds specified in the non-conforming use chapter that there's a 10% number in terms of intensification or even reduction in use impact as well of 10%. So, yeah.
Can we, as Planning Commission, add another condition of approval so that would deal with some of these non-conforming uses? So if the City Commission has given them a business use for a year, can we have the non-conforming uses addressed in a year?
Certainly can add a condition along those lines, yes.
And with the information that you were saying from this 1990 record or 1990s, I didn't catch the...
Yeah, conditional use permit.
Yeah. Okay.
So I think the options that you're talking about would be to set a timeline for when the applicant must get this non-conforming use verification for the home in the institutional zone and the industrial
The flotation, yeah.
the flotation use. Or you could continue this and we could, maybe the applicant would want to amend their application to include a request for non-conforming use verification now.
Okay.
So we could do it now, would be the second option, I think. If the commission is concerned about the timing, because I think you're right that it is presumed in the lease that this would be done by the time the November deadline is up.
Okay.
Follow-up question to that. Well, I just lost it too. Okay, it'll come back to me. Well, if the record from the 90s comes back, those conditions of approval kind of grandfather Ken's, the non-conforming uses, would we still have the condition today? Right? If for some reason the record showed that those existed at the time and they were approved, what does that do to a non-conforming use?
It's not a non-conforming use anymore. It has land use approval.
So then our conditions would be null and void at that point, correct?
Well, I mean, they won't be null and void, they just wouldn't apply.
Sure, understood.
But I need to be very specific. The conditional use approval that we're talking about would have to include industrial uses for cancellation, and it would have to include a house in an institutional zone, which I don't know that it would.
Sure.
The timing would have to be right. We just don't know enough about the sort of chain of uses and the changes in the code over time.
Yeah.
And I think the thing that's important about the industrial use, more so than the residential use, is we need to know about the intensity and the scope, right? Because you get a non-conforming right to do a certain intensity and scope. And we don't know what that intensity and scope was when the industrial use was established or as it has continued over time, because it can't be abandoned and it can't be enlarged, right? It has to stay the same. So that's the part we can't hurdle right now.
Thank you for that.
I guess my last question or concern, there are certain businesses that by their very nature require that they be on the water, and I would assume that flotation construction is one of them. You have to have a boat, you have to have a pile driver, you have to be able to transport docks and so on. So other than this specific business, that's not allowed in the city essentially, correct? Well, but the MUD is.
We have a general industrial zone, but it, you know, these are unique uses because, as you say, they're on the river, and our code is very limited in what it says about on-water uses. It doesn't address floating homes. The building code addresses floating homes. The zoning code has nothing in it. The Marina was added as a permitted use to the zones in 2003. But yeah, the light industrial, the industrial use, particularly marine industrial use or things of that nature, are not talked about in the zoning code at all. Yeah. In this zone district, so.
So what other kinds of businesses are allowed at the marina? So for instance,
I think
marine towing, charter fishing, excursions, things of that nature.
Right. I think tourism-related uses, which predated on the river, like in the old M1 zone, that would come to light out of a non-conforming use review because the M1 zone districts listed out very specific types of uses and became more generalized in 2003 with the adoption of the mixed-use downtown zone and the institutional zoning. So I think the non-conforming use review teases that out and allows for a more specific comparison of industrial use types, potentially. So, but I couldn't make that determination right now. Yeah.
Okay. I'm just trying to pull up the definition of marina because I just want to see what it says as far as what marina means, because that could be whether that's the docks or the use or. Oh, it's not defined.
No. We are looking into marina, and if it's defined, did you say it wasn't?
It is not defined.
Yeah.
All right.
What page are you on?
Oh, I don't know. I'm on the municipal code on the website.
Oh.
Yeah. Okay.
However, I'm sorry if I'm sounding a little confused here. In the prohibited uses in the MUD on 17.34.040, heavy equipment service, repair, that kind of thing was not allowed.
Yeah.
But you said we're not here tonight to review any of that.
Unless you had a condition of approval in that regard, and we would want to give the applicant the opportunity to add evidence into the record about that use and how long it's been in operation. There are a variety of different types of evidence that can be used to make a non-conforming use determination, including business records, affidavits, things that are not in the record currently, other than what has been explained in the narrative. So the non-conforming use process allows you to add those exhibits, and you get when there is a preponderance of evidence to support both established and continuous non-conforming use, that's when you can make that determination as staff.
Sorry, I'm looking up the definition. Okay. Any other questions for staff? Yeah. Yep, go ahead.
All right, unfortunately, a lot of thoughts are developing. Is this the first master plan that the marina has had to produce?
I believe so, yes.
What sparked that? What caused this?
I am not privy to all of the events leading up to it, but it is a stipulation in the most recent agreement for the lease. So, I mean, it says that the applicant shall provide a comprehensive master plan documenting existing uses on the site. And I'm paraphrasing, yeah.
And I understand that we don't have a lot of good code in the city codes because there's not a whole lot of stuff happening on the water. Now, when I know our records don't go back forever. How old is the marina?
1970?
Okay, well, we had code in 1970.
Just a minute.
That's probably a question the applicant can answer when they give their presentation.
Right, they're gonna have a chance to speak and they're gonna probably have some information that is gonna be very helpful. What I'm trying to figure out is, when a city does zoning and code, do they investigate every business that's operating within that zone before they do some zoning code changes to make sure they're not coding someone out of an existing use? Is it possible that the code just wasn't properly done at the time and maybe that business was there and maybe the house was there and we just didn't do the zoning right? Is that possible?
Well, when rezoning happens, it's usually a legislative process, and it is, especially when it comes to zoning on this level, it's a citywide legislative process, and there's public notice provided now to all owners within the city limit. And the city does not do analysis on each and every use to see whether or not that use is going to become non-conforming or that structure is going to become non-conforming. But that inevitably is what happens when zoning and development standards are updated and amended. And the majority of sites and structures become non-conforming because you may have a new landscaping standard, or you may have a new height limit, or something that regulates the physical nature of that site. So that's the site structure part of it. Uses that pre-existed are allowed to continue as long as they are not discontinued for a period of a year or more. That's the non-conforming use part of the code. So.
Okay. All right, thank you. And I'm eager to hear from the applicant.
Okay.
So, I'm looking at this master plan, with pictures and everything. It's 149 pages. And I see a lot of, obviously what the city would like required. I would have to keep this on the table all the time to follow it. What's the city's obligation with this master plan to Sportscraft?
Well, on the one hand, the code allows an applicant to request up to 20 years. Within that time frame, they can, and by their choice, they can use the code in existence at the time that the master plan is approved for any subsequent development within that 20-year period. So they're allowed to rely on the code in effect today and use that code for any subsequent developments, so they get some assurance that the code will not change. That's one advantage of a master plan. I can only speak to the land use criteria. So, yeah.
The last thing as well, I was going to say here, does the city itself, see an opportunity here long-term for this business to be here for tourism? Because the city commission has discussed a lot about tourism. And, obviously, they do what they do. They've been doing it. But does the city see the opportunity to continue this in terms of connecting the city to the water, basically?
I can try to speak to that a little bit, and only to say that the Community Development Department was not part of the leasing discussions, and I haven't heard as many discussions, just personally, they probably have taken place, but about tourism itself. So I can't speak to, and I don't know that we can actually answer the question that you're getting. And I understand what you're asking, but we weren't asked to make any kind of conclusion about that as part of this land use. It's admittedly a little bit clunky, because the question that you asked before, what is the city's, what does the applicant get out of a master plan? And as Pete said, it locks in code for the duration of that master plan, which is usually or it could be advantageous for someone who's developing over, a certain number of phases over time, and then they know exactly what code they're obligated to. So that would be the same for this applicant as well. And then as to your tourism question, I'm not sure that the people in this room have the answer to that.
I would like to add, though, that one of the criteria for approval of a master plan is compliance with comprehensive plan policies that are pertinent to it. And we have made findings for consistency with Chapter 2, diverse economy of the Oregon City Comprehensive Plan as pertains to tourism and supporting the uses in the downtown area. So.
Thank you.
Sure.
Question for Ms. Richter. If we don't have the definition of marina in a code, what definition would we rely on?
The definition from a dictionary?
A dictionary, or I found in the OARs or ORSs, I'm not sure which. Anyhow, there's a definition of marina. Would that be, if we're going to the next highest level of government that defines it, or just the dictionary?
No, I think that the way you would do it is if you have a definition that you think would be a reasonable one, you would offer it while the record's open, and the parties and participants would have an opportunity to suggest that that is the right definition or a wrong definition.
Okay.
I think the important part is that whatever definition you use, it needs to be consistent with the purpose and principles underlying the MUD zone. So I'm assuming there's some kind of purpose statement in the MUD zone that I can look at, and whatever definition we use would have to not be inconsistent with that.
Okay. Just give me a minute to read that. Yeah, none of it's really, I don't think, applicable. Okay, come back to that. Is anyone interested in hearing what the state thinks a marina is? I'll just put it out there on the record as soon as I find the right tab. So this is, again, I believe it's an OAR, but, it's an OAR. Chapter 141, Division 82, 141-082-0255, definitions. Definition 50, marina means a small harbor, boat basin, or moorage facility providing boat berthing, docking, and mooring, and incidental services for recreational, commercial, and/or charter fishing boats. And I tried to apply the incidental services part in this instance. All right, any other questions for staff? Okay, we will move on to the applicant. All right, please state your name, city of residence, and you'll have to get pretty close to that mic to make it work.
Probably can hear. Gary Spanovich, 4044 Southwest Trail Road, Twelton. And I'm project manager on the project of the master plan. Nancy?
Nancy Olmsted Spanovich, 4044 Southwest Trail Road, Tualatin, Oregon, and representing the primary land use and natural resource planning elements of the plan.
And we're basically urban and rural land experts.
I think you'll have to get closer to the mic to,
We're
yeah.
We're urban and rural land experts. We, between us, have 70 years of land use, transportation, and environmental and wetland experience. And it's my understanding that the need for this master plan came about as part of the lease agreement because a lot of questions were raised through that lease process that people didn't really understand, or the city didn't understand what was down there. And they wanted to document what was down there, and that's why the master plan looks like it does. So it's a good line in the sand, so to speak, of what's there. And it's evolved over, as Ken said, started in '58. So what are we looking at? We're looking at over 60 years. And in that 60 years, there's been a lot of land use changes, a lot of different codes. And what you see is an evolution of that. It is a really important use for the city of Oregon City. It's one of the few recreational marine river uses, and people can access it in many different...
I have an answer for that. Is there something else I can help with?
Is that my phone? No, that's my... Yeah, it is my phone, but it's my smartwatch phone. I better put it on. Sorry about that. I don't know what to do, except move it away from my voice, yeah. I mean, that's kind of an introduction. And then Nancy has prepared a presentation, what's in the report, and you can go through that or just answer questions. He did a great job with, so I'm not sure any point in repeating what he said. So would you like Nancy to go through content? Yes?
It's your presentation, so whatever you'd like to do.
Overview.
I won't talk more about I think Pete's presentation was a good background on everything that was included in the master plan. Wanted to point out that the master plan did address the existing uses, including these two zones that we're talking about. So I wanted to drill down a little bit on that because downstream is now called institutional I, which is public and quasi-public. And on the surface of it, the new zoning actually really suggests this is the perfect use for this site. And then it splits right in the center, and upstream is mixed-use downtown. Mixed-use downtown is the one we've been discussing that has, includes a marina, but it includes other things too, because of the hope, of how the city will develop. And I wanted to just point out that the master plan itself did drill down, looked at all the public record, also talked to the client, the applicant, and looked into the historical record. There's things that are not in the master plan that could be evidentiary. However, they didn't appear to be that at the time, because what we wanted to do is put together a good picture of what you can't really see from McLaughlin Boulevard. You really can't see it. All you see is the sign, and you see the beautiful river. But this tucks in so beautifully, and this is a project that was permitted, it's maintained, it's highly regulated by, federal as well as state because of the aquatic lease, and they've kept everything up to date. but it also has a nice zone. And I think the idea that the master plan presents at least a foundation for us to look at, and provides some detail on existing uses, it could look into the appendix and you could see that that particular site has been under different comp plans. 1965 sticks out to me right now when I think about a number of different sites along the river were industrial. Different, I couldn't tell you the detail of any of that, but it could be found out. Because we looked at current conditions and current comp plan and current zoning. And generally found only those two items that there wasn't a specific, it could be non-conforming, could be considered non-conforming, and possibly not enough evidence. I think we got enough evidence in there for the residents. And the idea with the floating homes is there's somebody on site that takes charge and manages what's going on there. And it is a beautiful public asset. It's a public use area, and it serves the city well. I don't really have a whole lot more that I'd want to discuss, because I think, the presentation already was very comprehensive. So if there's any other questions, feel free. I'd be happy to address them.
Okay, anyone have any questions for the applicant?
I just have a comment. When I was reading that, did it say that Crown Zellerbach had donated this to or sold it to these people? But you just, talking reminded me of that. They used to have log booms down there. I forgot all about that. So yes, things have really changed on both ends, the city and business through the years. It's just a comment.
Mm-hmm.
All right, any other questions for the applicant? No? Okay. All right, thank you. Are there any representatives of a recognized neighborhood association, government agency, or other incorporated public interest organization? All right. Any individuals that wish to testify? No individuals that submitted cards?
No, those cards are from Gary and Nancy Spanovich.
Okay. All right. Well, time for discussion then. Or motion, either way.
I guess when I first started reviewing it, I was struggling with a general development plan with aerial images and kind of, not specificity, but understanding now and hearing the record, hearing the history, it makes sense. And given staff's, conditions of approval, I feel comfortable with that. So I think good job on the staff side, and thank you for the applicant.
Anyone else? Commissioner West.
Oh, I don't know how to state it, but I was saying earlier, or mentioning earlier, that the non-conforming uses, that they have a timeline on them. And so I'd be willing to make a motion to approve it with that additional condition of approval. And if they wanted to add more, Nancy was saying they might have more information out there too that they didn't think at first was pertinent. And if you have more information, Pete, that you're gonna, that the city can go through a few more records that put a timeline on this so everyone can move forward.
Yeah, as part of the non-conforming use process, we include both whatever the applicant can provide and any public records that we can garner through public records request process, which I believe we've looked, but knowing this, I'd like to look at this conditional use issue and see what was available back then, because I think that would help. And I don't even know which uses it's stipulating about, but it will definitely be part of the evidence, yeah. Mm.
Is that something that you need a continuance for, or is that part of the after this is approved, the conditional use, or the non-conforming use process?
Yeah, November 31st, I believe.
What I would, with the commission's permission, I would suggest that we could make an amendment to conditions 3 and conditions 4 to add a clause at the end. So it was condition 3, it would say continued residential use or expansions of or improvements to the floating home within the boundaries of the I institutional zone is permitted subject to review pursuant to OCMC 17.58, lawful non-conforming uses, structures, and lots, which shall be obtained in final form on or before November 15th. And so we would add that clause to both 3 and to 4, so that the applicant would be required to get non-conforming use verification for the continued residential use and the continued industrial use for Ken's Flotation Services on or before November 15th. Pete is checking the lease right now to make sure that November 15th is the date. We think it's November 30th, so that gives us a little bit of slack.
Okay.
Because certainly any extension of the lease will need to be negotiated before it expires.
The terms of the lease are through November 30th.
November 30th, 2024.
So it would be November, if we said that the applicant had to get this non-conforming use verification on or before November 15th, 2024, that would be sufficient time. So that means the applicant's going to have to start that process earlier than November 15th in order to get it by November 15th.
Okay, and I'm, just to understand the process, is the purpose of this what in my mind is a very short lease for something like this, is that to get all the paperwork done and then there'll be theoretically a longer term lease after?
I have no, that's not before us to decide.
I was just trying to get my head around the whole process. Okay. Commissioner Schlagenhofer, you had a question?
Just a thought that, I feel that with what we were discussing just now, I feel like we can approve this the way they're conditioning it. The applicant has a task, and the task is to come up with historical data that supports the non-conforming uses. But our position to approve the master plan, I think we can do that, and you know they've got a lot of work to do that we don't really have to be involved in. That's after us. But as long as the dates are set, they know what they need to do, when they need to do it. I think the master plan looks fine.
Okay. Any motions?
Motion to approve it as conditioned. We were just discussing.
Okay.
GLUA 23-00026 and MAS, the master plan 23-00002. Is that right? Did I get the number wrong?
No, you got the number right. Does the motion include the amendments to the conditions that I read?
Yes.
Or not?
Yes. Right,
Okay.
that's what we agreed on? Okay.
I'm sorry to interrupt, Chair. I was motioned to by the audience that somebody would like to speak. Do you care to reopen the public hearing? Or?
Yes, we certainly can.
My name is Eric Dye. I live in Oregon City, down at the Marina. I just wanted to state that we haven't had a long-term lease for quite some time. We've been on one-year leases for almost 4 years now. Actually, 2 of those, we didn't even have a lease. Before that, we had a 5-year lease. Before that, we had a 20. So we've been kind of in limbo for quite some time, trying to work this all out, trying to figure out what our future is going to be there. The Ken's flotation issue on the industrial site allows us to have a 200-foot by 30-foot area on the outside of our marina on the south end, which I paid Division of State Lands a water lease zoned as industrial through Division of State Lands. I was required to get that by the city before I built the Marine Patrol building. So it was approved by the city at one time, and hopefully it will continue. I've been in business, flotation's been there since 1988, so. And I hope to continue that and my son, for many years, so. That's it. Unless you have any other questions.
Any questions? No? All right, thank you.
All right.
Okay, so I believe we have a motion on the floor. Okay. As amended, correct?
Correct.
Okay.
I second.
Okay, motion's been made and seconded. Any discussion? All right, call the vote, please.
Commissioner Dole?
Aye.
Commissioner West?
Aye.
Commissioner Laws?
Aye.
Commissioner Schlagenhofer?
Aye.
Chair Stoll?
Aye. All right, thank you.
Thank you.
Yeah, we'll take a 5-minute break.
Turn the video on. Camera.
No, he didn't understand.
Testing. All right, cool. All right, call the meeting back to order. Next is climate-friendly and equitable communities parking reforms.
All right, good evening, Commissioners. I would just like to start out by saying that when I presented this item as a work session item to the City Commission, I cleared the room. And as you can see, the room is clearing. It's that interesting of a topic. So here we go again. All right, so what we're going to do tonight is just kind of walk through, walk through climate-friendly, equitable communities. We'll do just kind of an overview. There's no decisions tonight, and I will report out on what the City Commission's policy direction was what they gave us. So the timeline, we submitted, I'll back up a little bit. So the Department of Land Conservation and Development offered some grant funding to go through and make the code amendments that are required. So we submitted for a grant application, and just today, we were notified that we were basically given a preliminary funding award. And so we have yet to work out the scope and budget of what that means. So that was the first piece of this. And so we'll spend the next, I'm not sure how long it will take, but through the spring, probably kind of getting that going, getting the contract with DLCD set up, and then going out for a consultant. We'll either work with DLCD to do that or send out an RFP. Then I anticipate that over the summer, we'll work through code language, draft code language, so you have that to look forward to. And then we'll go into legislative hearings this fall, and we will, we have to adopt the new code reforms by the end of this year, December 31st, which we were just given an extension for that. So we're set there. Thank you. So what is CFEC? Climate-friendly and equitable communities is a set of Oregon administrative rules that have gone into effect. In March of 2020, Governor Brown issued an executive order that called the Oregon State Climate Action Plan, and it directed multiple agencies to take action to mitigate the effects of climate change. So Department of Land Conservation and their policy body, the Land Conservation and Development Commission, adopted these administrative rules aimed at reducing climate pollution, providing more transportation and housing choices, and promoting equitable land use planning outcomes. So back in 2007, the Oregon legislature had adopted a goal to reduce climate pollution by 75% by 2050, and then in 2022, it was found that Oregon was off track from meeting the goal. And so these Oregon administrative rules are intended to help get there. So the implementation requirements. So these are kind of the major task groups. One of them is already in effect, and that is the administrative rules call it a climate-friendly study area. And in the metro region, the regional centers and corridors and town centers comply with that. They comply with that code. So we already have a regional center adopted, so that piece is taken care of. The additional reforms that we're going to talk about tonight are the electric vehicle conduit code amendments, parking minimums, and then parking maximums and other code reforms along with that. There's additional reforms that will come in the future, and that they'll be wrapped into basically how we put together our transportation system plan. So there's new transportation planning rules that our TSP will have to comply with. And then the next time we do a housing needs analysis, we have to actually identify how, part of that will be a housing production strategy. So how we're going to see some of that housing produced. And that's not until 2027. So that is all in the future. And the TSP will start in 2025. So right now we're just kind of working on land use codes. So these are the 5 different sets of reforms: parking minimums, parking maximums, electric vehicle charging, parking design, and bicycle parking. And so this is kind of the first Reform 1, parking minimum. So the first decision that the City Commission had to make is whether or not they wanted to look at eliminating all parking minimums throughout the city. That it does sound daunting, but that decision actually only affects kind of a small section of the city, and you'll see that in a map to come up in a few slides. So I'll walk through some of these slides and then we'll look at that map. So category 1, and this is tiny print for a slide, but these regulations are actually already in place. They went into place, I think, December 31st, 2022. And so we have to comply with basically what's in place from the state. What we'll need to change is our code so that our code is reflective of the state code. So when planners are talking to applicants, we're not trying to figure out like multiple sets of codes and what applies. So just to walk through these really quick. So in category 1, there's no minimum parking required within half a mile of a TriMet frequent transit line. So for us, that's line 33. No minimums for small housing, less than 750 square feet, affordable housing and public supported housing, childcare facilities, residential facilities, domestic violence and emergency transitions shelters. And then we can only require one parking space per unit for middle housing and multifamily developments, which we actually already meet that. That went into effect when we did the equitable housing. Okay, so that's category 1. And I guess, spoiler alert, the city commission gave direction not to eliminate all parking minimums. So what that means is we will now be working through these next set of decisions, and that's what this consultant will help us kind of work through. So in category 2, we have to comply with A through D, and then as we're working our way through A through D, there are different sets of policy decisions. So we'll have to reduce the minimums around shared parking, solar panels, EV charging, car sharing. This list is spelled out in OARs about how much you can reduce the parking by if a developer proposes some of these things. Or I shouldn't say can, how much we shall reduce it if the developer proposes something from this list. And then we can't require garages or carports. So then we have to do those two things, and then there'll be a decision point in around the regional center, and that is whether we remove all minimum parking rules within a quarter mile of the regional center, or do we create a parking district with paid on-street parking, change the minimum parking for residential to maximum of half a space per unit, and remove commercial parking minimums. So there's some choices to weigh there. And then the next decision point, we'll have to choose from one of these two, D1 or D2. And I have just listed them this way, so if you see it out in the world somewhere else, it's the same wording, but it looks a little different. But this helped me identify how we have to work through this. So we have a set of policy choices there. I won't necessarily read through them all, only to say that in D1, there are options that don't really get into land use. So some of the options are about requiring development to separate leases, separate the how they charge for parking from a residential unit, or how they charge for parking from a commercial space. And so it's not something that I think anyone in any department in the city does right now. So that's a whole new set of processes that we'd have to look at. The second option, D2, is, I think, more rooted in land use. So there's a no mandate for this, or no minimums for this list of different types of uses. And then no additional parking for change in use, and then no mandates within half a mile walking distance of the regional center, and designating on-street parking or unbundling parking. So some of those things are more achievable in a land use setting. So this is the map that I was talking about in, I'm going to try to drive just a little bit so you can kind of, let's see, where's my mouse? Okay, so this black line is the TriMet frequent transit line. It actually, TriMet is proposing to move the line. So they're moving it from Lynn to, this is 7th and Malala, and then goes around the county, Red Soils campus, and still ends up in the same place up here at the community college. This line here is around the regional center. And so when we applied a buffer to the regional center and the frequent transit line, we get this buffer. And it's within this buffer that we're not able to apply minimum parking standards. Now this, I do want to say that a developer can still build parking, but we can't require it. So what this leaves us with when we're regulating is mostly residential. This is low and medium residential over here, and low and medium residential over here. And then over here we have some campus industrial and mixed use and some high density residential. But so mostly what's left to regulate is low and medium residential. And if you remember from a couple hours ago of your very first public hearing tonight, we don't currently have regulations for low and medium residential uses. So there's not much left that we will be regulating. Be that as that may, the City Commission was concerned that if we did not regulate minimum parking, that there would be spillover effects into these areas that we're not regulating. So, okay. All right, I'll give that back to you, thanks. Okay, so that's all the parking stuff.
So this, all the other, like you're showing with the diagram, all the other areas, it applies to single family, multifamily, commercial, everything. All the new,
The legislation?
yeah. So
It
they don't wanna
doesn't,
do, the first thing, no minimums, so the city council doesn't want to go that way. So then the other way now.
Oh, I see what you're saying. Yeah, no, it doesn't, the legislation doesn't apply to single family at all. It does apply to what they're calling small housing units. So that's 750 square feet or less. So that's pretty small. And then it does apply to multifamily when there's 5 units or more. Is that in?
Commercial.
And commercial, yeah,
Okay.
and commercial, yeah, yes.
And I just want to add a correction. This is not legislation. Nobody voted on this. This is a rule that executive branch appointees came up with and implemented.
You are correct. This was, as I said in the beginning, it was an executive order from the governor,
Yeah.
right?
Yep.
Yeah,
Just throw it out there.
right, so,
Can I say something real quick too? It's like, we're not requiring parking, but we're gonna have electrical cars that need charging, right? So eventually, what is the city gonna supply charging areas for everyone who parks on the street?
well, okay, a couple of things on that. So, good segue. So we are
Right there.
we are having to require that when there is parking built, that there will be the conduit available. It has to be developed with a conduit available, not the charging station itself.
Okay.
So right now, that's actually in place in the building code, and it requires, I don't know if it's the, let's see, let me make sure I'm getting this right. So the state code right now requires any non-residential use in a structure and a structure built to commercial standards to provide 20% EV capable parking spaces. And that went into effect, I think, July of '22, I believe. So that's in effect. And then what we will be required to provide is when there are new buildings with 5 or more units, we will have to require that 40% of those parking spaces are EV capable.
This is commercial now.
No. This is for 5 or more units of multifamily. For new. So not retroactive, but for new. Okay, let's see. All right, I think that's, so we'll get to that, we'll get to electric vehicle. And then, Commissioner Laws, to the other part of your question, PGE has been talking with the right-of-way manager in the city about how they can potentially provide some charging stations in some specific areas. It's not like the whole city is going to be electrified, but there'll be some charging stations available. A lot of details yet to be worked out with that one.
Can you go back one slide? State code requires any non-residential use in a structure built to commercial standards to provide 20% EV-capable parking spaces. Which buildings and codes are we talking about?
Okay, well, that's a good question. So that's right now in the building code. Which of the building codes? I don't know that part for sure. But that's not in our land use code. So
Is it new construction?
Yes.
Because 20% is a lot. I mean, you'd have to probably increase are we talking like if somebody would put in we already have Home Depot. If somebody was to put in a Home Depot, would they have to put in 20% EV capable parking spaces, the conduit for it?
Right.
The electrical draw on the grid would be insane. It doesn't make any sense to put that much conduit in the ground for something that I don't think is feasible. But, okay, I'm just curious what kind of construction we're talking about. So it's commercial standards. Would that include an industrial park? Is that commercial?
Yes.
All right, it's blowing my mind, but let's keep going, okay.
Yeah, go for it. Okay, so when parking lots are, when they are proposed, there will be maximums. And so there will be parking maximums that apply within the regional center. So let me back up a little bit. So this one, I think I'm still sorting out a little bit, but I believe these parking maximum requirements will only be in the regional center. I'm pretty sure I double checked that. So residential uses within half mile of a frequent bus line can have 1.2 spaces per studio unit. There's a maximum set of 5 spaces per 1,000 square feet of floor space. And then uses that are larger than 65,000 square feet cannot have parking lots larger than the building. So probably the only use like that in our regional center is Home Depot that Commissioner Schlagenhofer just mentioned. But most of our regional center is within the downtown, the mixed-use downtown. So there really isn't, that I can think of, I don't think there's going to be a lot of opportunity for a building that's 65,000 square feet.
The entire landfill.
Well, that's multiple buildings.
If it was to be developed.
Okay, so that's maximums, and then parking design. There's rules, restrictions on what parking lot design looks like, carpool, van pool, when there's more than 50 spaces. We'll need to allow for the redevelopment for bike or transit uses for some of the parking area, allow for and encourage underused parking, or redevelopment of underused parking, facilitate shared parking. Some of these things we already do now, so they're kind of minor tweaks to our code. I think we require carpool, van pool. A lot of places, a lot of cities within the metro region have been required to do some of these things for a long time now. Require new and redeveloped parking areas greater than 1/2 acre to do one of three things: install 40% tree canopy or solar panels or pay a fee in lieu. And require parking areas of more than 1/2 acre to provide trees and pedestrian connections. So that's parking design. And then there's bicycle parking reforms. We will be required to increase the number of spaces per unit in multifamily and mixed use. Require bike parking for retail, office, institutional, those things we're already doing. If off-street parking, vehicle parking is required, then bike parking has to be required. And then there's design standards to consider. It has to be lit, allow lockable storage, provide room for maneuvering and large cargo bikes. And then in the regional center, the city must provide bike parking and parking of shared bikes and small-scale mobility devices. I think small-scale mobility device is a fancy way of saying a scooter, kind of a thing. All right, so this is what other cities are doing. Most of them, and so to be honest, I put this together in January, and I haven't gone back to check to see if there's been any updates, but most cities are choosing to go the route of just eliminating the minimum parking, because there's, so many choose your own adventures after that. So that's what they've done so far. Okay, I'm going to keep going. And where are we at now? So the policy considerations. Okay, so the commission did support us. They did approve a resolution that supported us submitting the grant application, which I reported out earlier, and they gave direction to retain parking minimums. So that will lead us to lots more discussion, and we will come back to you in the spring with the next steps. And I have one audience member left. Thank you, Jerry.
I just have one rhetorical
Yes.
editorial. Is there any discussion in this recent raft of legislation that is going through about providing additional funding for mass transit? Okay, there I said it.
Okay, now I would like to petition TriMet to reduce the service frequency so that we don't have to worry about this so much.
So you don't have to do this anymore.
Yeah, exactly. I think outside the box on these things. If you tie a requirement to some external agency, you can get them to change their definition or whatever. Sorry. Anyhow.
Any other questions or discussion on that matter? Okay. All right.
Don't you know you're all getting jetpacks?
What's that?
You're all getting jetpacks.
All right, well, yeah, thank you for listening to that presentation.
Thank you for the presentation. That's good. All right, what do we got left? I think that's it, right? Communications. Any communications?
We will have a second meeting in February.
Okay. All right. All right, any other communications? Commissioner Schlagenhofer.
Okay, since everyone's still here and pizza hasn't ran out yet, what if drones become mainstream and we are actually able to go to work in drones. Is the city prepared to create some kind of parking guidelines for drones? We thought ahead. We're gonna hit that when we reach that day.
That sounds like a perfect thing to go into the transportation system plan. Yeah.
But we haven't discussed it yet. Cities aren't working on it. Okay.
No discussion of drones yet.
I feel we're about 10 years away. Maybe in the next update.
Yeah,
Thank you.
That involves the FAA, so that's
right,
a
yeah.
whole other layer of, all right. All right, we're adjourned.
Everybody loves this topic.